Welcome back. In Burnham versus Superior Court, the question arises whether we really have moved on from the regime of Pennoyer versus Neff, at least with respect to situations where an individual is served with process within a state. We also return to the case of Schaffer versus Heitner, which most understood to say that the international shoe analysis applies in all circumstances. But in the Burnham case, a plurality of the court says that that is not the case. So we're back to the problem of the plurality opinion. Here we have 4 votes for one approach to the facts of the case. Justice Scalia's opinion was joined by 3 other justices, the first plurality opinion. Then we have 4 justices who would apply a very different approach. Justice Brennan is joined by Justices Marshall, Blackmun, and O'Connor, so that's a second plurality opinion. And then there's Justice Stevens, the 9th justice, basically saying, I don't think that this case is very hard, and I don't think that it's a good vehicle for making law, so I'm not going to sign on to either view. Great, huh? Clear as mud. Well, with that as background, let's nonetheless talk about the case. Burnham involves a situation where a couple that married in West Virginia and moved to the state of New Jersey and had a couple of kids there decided to split up. Mrs. Burnham takes the children and moves to California. Before she leaves, the couple apparently agreed that they would divorce on grounds of irreconcilable differences. But after Mrs. Burnham and the kids are in California, Mr. Burnham files for divorce in New Jersey on different grounds: desertion. What's the first procedural issue here?
That she was never served with process, so she doesn't know about the divorce action.
Exactly. Mr. Burnham goes to California on business, and while there, he also swings by to visit his children and spend some time with them. And while he's there, he's served with process in the state of California in a divorce action that Mrs. Burnham initiated out there. Now, because Mrs. Burnham was never served with process in the New Jersey case, the California court does not defer to the New Jersey action. Okay, so what's the procedural issue in the California divorce action?
Whether the California court has personal jurisdiction over him.
Right. And all 9 justices on the Supreme Court agree that the answer is yes, there is personal jurisdiction over Mr. Burnham, but they get there by traveling very different routes. What does Justice Scalia's plurality opinion say? Online student? Lisa?
Well, they say that there is personal jurisdiction over Mr. Burnham because he was served with the divorce papers in California, and that's good enough.
Right. Justice Scalia, writing for 4 justices, suggests that there is personal jurisdiction because Mr. Burnham was served with process in the state of California. We are therefore in that first category of Pennoyer versus Neff. And, Justice Scalia says, in 1868, when the 14th Amendment was adopted and ratified, it was widely understood that service of process on somebody while they are within the territory of the state allows for an assertion of adjudicatory jurisdiction over that person. And that's all there is to it. Because it was understood that that would be the case in 1868, it needs to be understood that that is the case today. For Justice Scalia is an originalist who believes that the meaning of the 14th Amendment from 1868 must be the same when applied even to today's cases. Under Justice Scalia's view, it is always okay for a court to assert personal jurisdiction over a defendant who is served in the state, even if the person is only in the state temporarily and has very few contacts with the state. Now, what about Justice Brennan's plurality? What does it say?
They say that there's a new test. It's the international shoe test. Mr. Burnham was in California of his own free will and using roads and other things in California that he used if he needed to or wanted to, and his children even lived there. So that's the new test, and that's why there's personal jurisdiction.
Very good. Justice Brennan says that Justice Scalia reaches the right result, but for the wrong reason. He says that when we moved from Pennoyer to international shoe, we moved from a formalistic territorial approach to a more realistic approach which focused on the fairness of the defendant to facing this particular suit in this particular state. Justice Brennan says, on the facts here, it's fair for the defendant to face suit in California. He was visiting California, he used its roads, the services of the state presumably were available to him where he didn't need them. And he might have added that his children lived within that state and that the adjudication involves the state's interest in adjudicating the status of a family that is now in the state of California. But the test is no longer whether the defendant was served with process in the territory of the state under Pennoyer. Rather, Justice Brennan argues, it's the international shoe test. Justice Brennan says that's what we decided in Schaffer versus Heitner. Now again, what was decided in Schaffer versus Heitner? James?
I think it was whether international shoe could be applied to a person instead of a company.
Right. The question in that case, answered in the affirmative, was whether the international shoe analysis should be applied in the case of an individual defendant rather than a corporation. Justice Brennan says to Justice Scalia, your conclusion is right that there's personal jurisdiction over Mr. Burnham, but your analysis is wrong. Rather, the analysis should turn on whether or not it was fair under the international shoe standards for Mr. Burnham to face this lawsuit. And it was. Okay, question. Let's say you're on your way to vacation in the state of Washington and you're passing through Idaho to get there. You have no intention of staying in or returning to Idaho. You've never been there before. You stop for gas and are served with process in Idaho. The lawsuit at issue has to do with a car accident in New Hampshire. It has nothing to do with Idaho. Which approach, Justice Scalia's or Justice Brennan's, would be better for you? Online student? Lisa?
Justice Brennan's, because it's based on fairness, not on territory like Scalia. Under Scalia's approach, the fact that you were served in Idaho is the end of the story.
Right. Under Justice Scalia's approach, it will be okay for Idaho to adjudicate that claim against you. You were served with process in Idaho. End of story. For Justice Brennan, however, the answer would be decided on the basis of international shoe and its progeny, and would turn on the fairness of having you face suit in Idaho on that claim. What about Justice Stevens?
Well, he's like, you've got two people getting a divorce. What's the big deal? Either California or West Virginia works for personal jurisdiction.
Right, except that the choice is between California and New Jersey. Justice Stevens says, I thought we said too much in Schaffer versus Heitner. I think we're saying too much today. This is an easy case. Of course, when you're talking about a divorced couple and they live in different states, the two states where they reside have to be proper locations to adjudicate the divorce. That's all we need to decide on the facts of this case. Okay, to sum up, if you take Justice Scalia's view, Burnham suggests that there is general jurisdiction over somebody who is served with process within the territory of the state, period. Any time there is effective service of process on somebody, well then that's going to be enough to attach personal jurisdiction. But Justice Scalia's opinion in Burnham was only a plurality opinion. There was also the plurality opinion of Justice Brennan that says, no, we do an international shoe-based, fairness-based analysis. So the question remains open, as plurality opinions are not precedential. Okay, let's move to the notes and problems in the next segment.